Supreme Court heard arguments on campaign financing this morning. A challenge brought on by Republican Senator Ted Cruz from Texas takes aim at a federal cap on spending. And this is impacting politicians' ability to use campaign funds to recoup personal losses. Corporations and unions are already allowed to spend unlimited amounts of money, and some believe that that can lead to corruption with a lot of dark money coming in from unnamed sources. Let's go ahead and bring in our chief legal correspondent, Seema Iyer, here, who observed the High Court's arguments today.
And Seema, this lawsuit, as Brian just said, it was brought on by Senator Cruz, and now he and his campaign have admitted to such. Now, did the prosecutor rely on that information today? Because there's a lot to process with this.
Oh, yeah. I mean, how could you not? If it's a fake lawsuit, I'm going to bring that up all day and night if I'm the prosecutor. So let's just remind everybody what I am talking about, okay? The day before the 2018 election, Senator Cruz donated $260,000 to his own campaign. After all the contributions came in and after the campaign was over, the campaign was allowed to pay him back that $250,000 because that's the cap. So he is suing about the balance, that $10,000. Now, the Solicitor General, who is the prosecutor in this case, he spent a lot of time talking about the fake lawsuit, but he was challenged on this issue by Justice Thomas, who's been a very chatty Cathy this term, and he brought up the 1896 landmark civil rights case of Plessy versus Ferguson. In that case, a mixed-race gentleman purposely violated the separate but equal train rule that was employed at the time, and the gentleman boarded a whites-only car to challenge the law as unconstitutional. Listen to this exchange.
You said a number of times that these self-inflicted injuries can't be a basis for standing. At least that's what I understand. But how would you, using that at that level of generality, what would you say about Plessy sitting in the wrong car?
We would not say that that is self-inflicted in the relevant sense.
Why not? I mean, it's just all he has to do is go to another car.
That is, Plessy is attempting to assert a legitimate constitutional right and is attempting to do something in the real world that presumably he would do if the law were not on the books.
So, fascinating to note, Plessy versus Ferguson is actually just one example. There have been several other civil rights race discrimination cases where plaintiffs have initiated lawsuit and the Supreme Court has actually upheld these actions. So, bottom line, this precedent, good for Mr. Cruz.
Good for Mr. Cruz. Yeah.
Yeah.
One of the things here seems to be the purpose behind this law is to prevent corruption. How did Cruz's lawyers address that with the justices today, though?
Okay, so their argument was that the Federal Election Commission hasn't cited any evidence of this quid pro quo corruption in post-election contributions, okay? So this is not pre-election, this is post-election. But the justices did challenge the possible corruption after the election, as well as the intent of the contribution itself. Now I want you to take a listen to Cruz's lawyer go up against Justice Sotomayor.
Congress cannot seek to deter, as opposed to seeking to deter and to prevent actual quid pro quo corruption, then those are reasons, Your Honor, those are reasons enough for a contributor to come after an election and make a contribution to the winner. It's just that the candidate has now become effectively an incumbent.
But you just said the magic words, to make a contribution to the winner. Not to a campaign and for its debts, but for the pockets of the winner. That's a very different corrupting influence.
Ouch, that was a little cringy. But now here's the deal. Everything in the law, you guys know, has a definition, and corruption has been loosely defined. In the definitive campaign finance case, a lot of you may remember this, Citizens United was from 2010. The problem, again, though, in that case, the definition was kind of flimsy. So Cruz, once more, has the benefit of a conservative-leaning court.
I mean, there is a lot in this. You got quid pro quo, this for that. I mean, finally, the big question here is, you know, this contends on these caps, violating the First Amendment protection. So how did the government counter that whole argument, saying of what Senator Cruz is really kind of laying out in this case?
Well, they're saying, okay, so political speech comes under the First Amendment, and that is protected. But they're saying these are post-election contributions. So this is after the political speech. The whole idea of political speech is you can say what you want to get your candidate elected. But the bottom line is everybody knows people get reelected all the time. So in my opinion, you know, a good lawyer is going to say political speech is a continuing conversation, and contributions, we all know this, people make donations to their candidates for decades. So
Yeah.
I think that was a little flimsy.
Yeah. You know what's fascinating too is to hear the justices themselves, as opposed to we always see them. I love hearing what they have to say in court today.
Yeah, thanks to C-SPAN, we got all that, and you got to see the lawyers too.
Yeah, all right.
It's fun.
Yeah,
Good
Seema,
stuff.
Thank you so much for joining us today.